everyone. Welcome to LexTalk World Talk Show presented to you by ClickAway Creators. Today we have Mr. Faisal Sherwani as an advocate on record, Supreme Court of India, and is currently a partner in the dispute resolution practice at L&L Partners Law Offices, New Delhi. With an experience of over a decade in the field of dispute resolution and dispute advisory services, he has a deep understanding of procedural and substantive issues of law. He has a host of reported judgments to his credit. He has continuously, advised and acts for clients on the range of subjects, such as constitutional law aspects, arbitration laws, corporate, commercial, and insolvency laws. Along with that, labor legislations, white-collar crimes, and penal laws. Hello, Mr. Sherwani. How are you?
Very good. Thank you for inviting me. Delighted to be here.
Likewise. Thank you. Please brief us about your journey as a legal professional so far.
Well, honestly, I don't know if I would characterize it as a journey. I mean, a decade in the legal profession is a bit like taking baby steps in many ways. But I think I'll give it to you in a nutshell. I come from a middle-class family where my parents had the usual middle-class aspirations for me that I should study medicine or engineering. But they were astonishingly supportive in that they ultimately granted me the liberty to make my own intellectual choices. Went to law school at the Faculty of Law at Aligarh, graduated, went to the George Washington University in Washington, D.C. for my master's. Started as an apprentice at a very respectable senior advocate's office, Mr. Rakesh Devedi. Then had a longish stint at Parekh & Company, a boutique law firm. Wound my way up to L&L Partners, where I am now, and went up the ladder to partnership. During this time, I've had the opportunity to work with a number of great individuals for some splendid clients. And I've been very fortunate to have had the opportunity to work on an indiscriminate number and variety of matters. So I think the process of learning is continuing by virtue of, I think, being in the profession and living.
Of course. Thank you. Thank you so much for answering that question. Please tell us about your most memorable case and what do you think that were your key takeaways from that particular case?
It's actually very difficult to put your finger on that one memorable case. I think every case is memorable in its own way. And you learn a certain set of things from every matter. But I mean, since you put it that way, I'll think what instantly comes to mind is when I appeared in a constitutional challenge before the Karnataka High Court relating to transport technology aggregators legislation, which was challenged. I particularly fondly remember it because it was the first of its kind. I was being opposed by a battery of senior counsels on the other side. And the matter had ultimately ended in, I think, sincere praise from the Karnataka High Court for my assistance in the matter. And the bench had indicated that my submissions had played a big role in them coming to a conclusion. So I think that's the most memorable, particularly because it was the first of its kind at that point of time. The key takeaways were, I think, that there's no, supplement or alternative, rather, I should say, to hard work. That you have to live with the matter, that you need to breathe, eat that matter, and you have to learn to look beyond the confines of the short-sighted brief. I think those were the takeaways.
All right, thank you. So the kind of knowledge that you have, the experience that you have, we really want to ask you this question, that how do you look at the dispute resolution in 2020 and how it's going to change 5 years down the line?
Well, instantly, if we were to talk about the year 2021 as it is right now, it's obvious that we're still reeling from the impact of the pandemic itself, right? So all of the stakeholders and the people who are to play a role in the resolution of disputes, I think, are going to have to learn to continuously adjust to the effects of the pandemic. The courts have adopted technology. I think they're going to be expected to continue to be adoptive of technology. So far, being able to do well in this scenario has meant having a strong internet connection. That's been about it. But if you look at the client market, there are a number of negative impacts of the pandemic itself. Some sectors are more badly affected. You can talk about leisure, hospitality, aviation. Some have fared better: pharmaceuticals, logistics, technology. In all of this, I think the one thing that is going to have a huge impact is that there is going to be a long-term impact of the pandemic itself. We have just learned that possibly we don't need to have as many physical meetings as we used to have. So you're probably not going to have to take as many flights as you used to. We're beginning to learn that maybe we don't need all that office space also. So commercial real estate is going to take a hit. Different revenue streams are possibly, you're going to have to explore those. You can't take your old revenue streams for granted. They may not be as rewarding anymore. I think that's of the client market. If you look at in-house legal teams, they've had to cut costs. They're on a budget. This has in turn resulted in them requesting the external counsels like us to take cuts also. We've been required to squeeze a little bit more value for the client within that budget. So I think those are the impacts immediately for the year, I think 2021, and we are all going to learn to adapt to that. Lawyers have learned that they can work from home also. So I think the law firm, the short-term impact of the pandemic has been less severe than was instantly expected. If you were to now talk about, coming to the last bit of your question, since you said 5 years, it's difficult to say exactly how it's going to change, but what I can tell you is that it's certainly going to change. We had for the longest time expected that the entry of the foreign law firm in the Indian market was going to be the greatest disruptor. That didn't happen, and the pandemic is a fine example of the limited imagination of the human mind. You don't know what's going to happen tomorrow, but I think it's from the earliest possible times. I think William Forsythe in 1879 wrote in his book Horatius the Advocate that as the relationships of society continue to grow and become more complex, so will the job of the lawyer be more complex and complicated. So we will be required to adapt, constantly change. There will be disruptions, and I think we can expect that. How it's going to play out, I think your guess is as good as mine.
All right, thank you so much. Now, you're already a coveted legal advisor in the startup circles in India, right? So would you please tell us more about the array of work that you handle?
Array is certainly the right word for it. I'm a general disputes lawyer. So as much as I have an inclination towards certain subjects of law, sometimes circumstances deny me the luxury of solely concentrating on few subjects. So I, like you said initially during the very kind introduction, I do concentrate heavily on constitutional law aspects, arbitration laws, corporate commercial insolvency laws, like you said, technology and gaming laws. And it really goes down to this. I mean, a lot of people today say that a specialization is something that is essentially necessary today. I don't have a disagreement or a gripe with that. It's just that a general disputes lawyer sometimes does not enjoy that luxury. I can take you back in time where Lord Henry Brougham said very famously, I think every lawyer would know this. He said that a lawyer must know everything about something and something about everything. So I think what he meant was he had in mind a general disputes lawyer. And I think that's the way it has worked out for me also.
Wow, that made me smile too. So my last question, actually the second last question to you would be, what do you perceive as the major challenges in ensuring a more robust mechanism for the enforcement of law and punishment for white collar crimes in India? Great question.
So if you were to talk about enforcement of white collar crimes, it's a very thoughtful question, I might say. I think there's an increasing realization among professionals today that our system, the Indian criminal justice system, lacks the mechanism to grant a pardon or a leniency of some kind. And I say this really in the context of large corporates, where, for instance, a responsible corporate conducts, and this is not a hypothetical by any means, it's the reality of our times, where a responsible corporate conducts its own internal checks and audits and comes to a conclusion that certain irregularities or financial irregularities, so to speak, have been committed in a branch of its wide-ranging operations, the system really needs to permit the frank and honest disclosure of these shortcomings without the fear of excessive prosecution. And I think our system intrinsically lacks that. There is a system, of course, of plea bargaining, but it's entirely unsuited to the instance that I've just discussed. Like you have in the United States with the Department of Justice and the Securities Exchange Commission, can grant you a pardon, you can enter into some sort of an agreement for non-prosecution. Of course, you would have to, for deterrent effect possibly, and as a penalty, pay a fine which may be a high multiple of the actual financial irregularity. I think that's something that our system really lacks.
All right, thank you. Last question, Faisal. How do you view the present scenario of arbitration in India? And so this question also has 3 questions. So I will just say it in one go, and then you can, plan to answer however you want to.
Right.
The second is, does the regulatory landscape measure up to other arbitration-friendly destinations? Also, the last thing is, what is the future of ADR mechanisms in India?
So I'll take that bit by bit. I think the regulatory framework is certainly, it's promising. It does match up to the very many other arbitration-friendly nations as well. But matching up does not, necessarily mean that it has to be identical. Ultimately, we have to carve our own destiny in line with our own laws and aspirations. And maybe the regulatory framework does not have to be or need to be identical to X nation or Y nation. But I think the amendments in 2015 and 2019 to the Arbitration and Conciliation Act demonstrate that there is a strong conviction of the legislature to make India an arbitration-friendly destination. That apart, there have been a range of pronouncements from our courts which have mirrored this sentiment. There's also judicial sympathy today towards the sentiment that there should be minimum judicial interference. So I think all of that really goes to making India an arbitration-friendly destination. Now, you spoke of the role that ADR has to play. I think it's quite well documented that today that ADR mechanisms have numerous benefits, and they must continue to play an important role in the times to come. There's no doubt about that. They have certainly reduced the burden of pending cases before the courts. That's also well documented, widely acknowledged, and there has been a cultural acceptance to it. My only concern is, and don't get me wrong, to this extent, I think we need to continue to have faith in ADR mechanisms. My only concern is that sometimes the reasons which are touted for ADR mechanisms being a better alternative are that they're cost effective, they're faster, so on and so forth, they're more receptive. My concern about that is it often sounds like an apology for how our traditional court system is functioning, because that is what a traditional court should also be. It should be cost effective, it should be approachable, it should be fast. And I think our traditional courts need to continue to inculcate those qualities also, and they need to continue to be the primary fora for dispute resolution, with parties being at liberty to opt for arbitration or other ADR mechanisms if they so choose contractually.
Thank you so much, Mr. Faisal, for sharing such great insights with us. We really look forward to having a chat with you again in future on maybe some other trending topics in the international legal industry. For our viewers, if you like this chat with Mr. Faisal, please like and share this video, and also subscribe to Clickaway Creators YouTube channel to appreciate what we exactly do, and you have more coming from industry leaders, of course. This is Bharti for LexTalk signing off.